All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Patricia Millen, Chief Judge, presiding.
You may be seated. Well, good morning. Today is December 2nd, 2025. This is live stream. Oral argument is recorded, and the link is on the WCCA website. We're here on a petition to vacate a stipulation for settlement, workers' comp number 25-6614. The petitioner is Sara Dutton. The employer is Clinical Benefit Group, Inc. The insurer is Berkley National Insurance Company, as administered by Berkley Risk Administrators Company, LLC. I have two attorneys I recognize today. I have the attorney for the employee as Mike Scully. Mr. Scully, that's correct? I'm still going strong. And I have the attorney for the employer insurer, Brent Clefman. Am I correct? Going strong there as well. I'm going to identify the members of the court. I am Patricia Millen, the Chief Judge of the WCCA. I have here on my right Judge Deborah Sundquist. On my left, my other right. How many times did we practice this morning?
Apparently 0.
I have Judge Deborah Sundquist on my left, Judge Sean Quinn, second to my left.
You were going strong.
I recognize everybody but my colleagues. I have Judge Tom Christensen on my right, and I have Judge Catherine Hip Carlson on my far right. Each of you have 15 minutes to present your opening statement, argument, as you may call it. You will each start with a 3-minute of uninterrupted time to state your position. At the end of the 3 minutes, I'll stop you, and I will look to my colleagues to see if they have any questions. Are there any questions before we begin? Mr. Scully?
May it please the court, I'm Michael Scully here on behalf of the petition employee Sara Dutton regarding what's before us today is the petition to vacate the stipulation for settlement and the award on stipulation that were dated May 19, 2020 and May 22nd, 2020 respectively. That good cause exists to vacate this stipulation for settlement. It's based on a mutual mistake of fact. And it's all based on the stipulated average weekly wage of $1,730.76. In support of our position, and in our brief, we highlighted the Brazel versus Brazel Masonry case and the Mahar versus Agrigenetics Jake Seed case. In the Brazel case, the court found there was a mutual assumption of the average weekly wage was correct. That was determined by the employer and the insurer. In the Mahar case, the stipulation for settlement of the average weekly wage was vacated. The parties referred to the first report of injury versus the employee's actual wage statements, which is similar to some of the facts you're going to hear today. The respondent's finality argument lacks merit in this matter. This court has jurisdiction to vacate this stipulation for settlement and the award on stipulation in 2020 because the average weekly wage was never at issue in this matter. The litigation that lasted over 2 years in the beginning of 2020 through June of 2022 when Judge Kulsif filed his second findings in order. The issue was the nature and the extent of Ms. Dutton's injury, which was a low back injury, and her entitlement to temporary total disability benefits, which were paid and determined at the maximum compensation rate of $1,134.24. And that was the issue from the time that when she was noited in January of 2000, 2021, excuse me, or 2020, excuse me, all the way to again, when Judge Kalseth served and filed his second finding in order of mid-June of 2022. There were 2 NOIDs filed in this matter and 2 hearings in this matter, as been outlined and provided to you. And not until after this matter was settled, Ms. Dutton could not return to her pre-injury job because of her permanent restrictions and filed a claim and sought temporary total disability benefits. Discovered the original average weekly wage was incorrect. The AWW was calculated by the employer and the insurer based on her 52-week salary. As in the discovery that was found and provided to you and in the memorandum that we filed before this court, they took the annual salary of $90,000 and divided it by 52 weeks. Not the true average weekly wage or her true earnings as required 26 weeks prior to the date of the injury.
Mr. Scully, I'm going to interrupt you for a moment, and I'm going to turn to my colleagues and see if they have any questions.
Yes, Mr. Scully, I have a question regarding the average weekly wage. What was the employer's duty to get?
Duty?
Yeah, what was the employer's duty to get that average weekly wage correct on the first report of injury? Because that's the document you drew the average weekly wage from, right? That's one you used?
Correct, Your Honor. That and the insurer's primary of determination. Those I relied upon. It's the employer and the insurer that fill out the first report of injury. The employee has a duty to notify her employer that she was injured in the course and scope of her employment. And the employer files the average weekly wage, and that's what the employer used. I don't know who filled out the first report of injury, but the question, she has no duty to tell exactly what her wage was because the employer and the insurer have that.
Right, and you mentioned in your brief and again today about the 52 weeks, basically the salary divided by 52 weeks to get to the average weekly wage that was stipulated to. Is there any statutory authority for determining an average weekly wage based on that formula?
I'm not aware of any. Have I used that before over my career? Determining the average weekly wage? Yes, because we want to make sure that an injured party, an injured worker, an employee gets the benefits that are appropriately due and owed to he or she in this matter. But typically, as long as I've been practicing, it's always looking at the 26 weeks prior to the date of injury.
All right, thank you, Mr. Scully.
I have a question about one of the arguments raised by the defense in their brief, which was you made a petition to vacate the stip, but we also have these findings and orders and other documents signed by comp judges that repeated that stipulated wage. Do you have to petition to vacate all of those things? Should we consider this petition to be a vacation of all of those things, or should we make you go back to your office and file a new petition? I mean, what's your take on that?
My take is that the issue that is before us today was not a litigated issue. The findings and orders that were presented at a hearing in front of Judge Kalseth, those were the issues that he determined. This average weekly wage was not at issue. During the whole time, the 2+ years, from the time I began representing Ms. Dutton in March of 2020 up to the present, or till the end of the second hearing when Judge Kalseth filed his second findings and order in June of 2022, the issue was the nature and the extent of Ms. Dutton's injury and her entitlement to temporary
Right,
total
and I
disability
get that,
benefits.
but the average weekly wage was technically not really an issue in the original stip either.
In the original what?
In the original stip.
In the original stip, we stipulated to that.
Right.
Yeah.
So, I mean, it's like stipulated. It was never an issue
Right.
until she returned to work at a lower wage, and now temp partial became an issue and wage matters. So do we have to vacate all of those other orders too, where it's all stipulated?
No,
Okay, and why not?
because they weren't an issue in front of a hearing. The petition, in order to petition, it has to be something that you know, it was an issue. Or let me back up.
Yeah.
The stipulations that we have and the stipulation for settlement and the stipulations at the hearing, they were stipulated too. They weren't an issue. So the average weekly wage was not an issue. It was never contemplated. It wasn't a concern. When you look at that, the average weekly wage, the $1,760 or $1,730.76. When you take 2/3 of that, that's above the maximum
Right.
compensation rate. This is just something that was not litigated. It wasn't an issue. And so it's our position that it's an issue.
All right.
It can be.
So then my question is this, let's assume, vacating the one is enough, or maybe we can agree that we're vacating all of it, whatever it might be. Is it a mutual mistake of fact when, as the defense argues, well, you and your client certainly could have had access to all of the wage records. You could have sat down and grabbed her tax forms or her W-2 or whatever it might be and look at what her actual wage was and go, oh, this is wrong.
The W-2s wouldn't accurately reflect her wages 26 weeks prior to the date of injury.
That's true. But
That's
I assume that the W-2 wouldn't have even accurately reflected her whole year's wages because she earned more than just what her salary was.
Correct.
So,
correct.
I mean, if your client had access to it, is it a mistake? As I get, that seems to be the defense argument. It's not really a mistake. You just didn't do it.
I guess we just didn't do it.
Yeah.
And the fact is, during that time period, I'm not sure what records, and I'm the only party that's still hanging around,
Right.
as Chief Judge Millen indicated, because prior to Mr. Clefman, there were two other attorneys on this, and the judge on this matter is no longer practicing. In fact, the judges who heard the 239 conferences are never practicing.
Yeah.
But this, and I guess our position is this stipulated fact was never litigated. It was never questioned. It was never litigated. And I don't want to use this, and as I was reflecting, why we didn't get the wage records or anything like that from the employer and the insurer. And I reluctantly want to bring this up, but it was during COVID. And at that time, things were in disarray. And I don't want to make that as my top excuse. It's probably at the bottom of the line because we were and we weren't in our offices. We were taking depositions. Ms. Dutton's deposition was taken. My representation began in March. I filed an objection to discontinue. It wasn't until May 1st that we took her deposition of that year. And then subsequent to that deposition, Ms. Dutton hadn't received any benefits since January of 2020 or May of 2020. As I reflect is that this is a mother with two children that hasn't had an income and needs to get some money into the household. Now, those are just my recollection, and my file is, 4 feet long in doing that.
Mr. Scully, to follow up on that.
Yeah.
The Frankie versus Fabcon case, that was a 1993 Supreme Court case, Minnesota. And in that case, the court said in a mutual mistake of fact case, the inquiry is twofold. Number one, what was the situation at the time? So what you're describing there to me was the situation. Would you say that the situation at the time, because it was COVID, because things were closed, it wasn't normal, that weighs more in your favor? And secondly, what was known about the average weekly wage at the time of settlement? Those are the two inquiries that the Frankie versus Fabcon court asks us to review. Can you reflect on that and talk to us a little bit about that?
And I'm reluctant to answer that question because it's, what I remember, what I recall. And I just recall that subsequent to that deposition, my client's deposition, the employer and the insurer agreed to pick up the temporary total disability benefits. And there was there was a question of whether or not she was really disabled because she took a 1-week vacation that was pre-planned prior to her date of injury. And that was one of the issues. The other issue is is to, you know, clients are desperate for money, I mean, you know, I shouldn't say, it doesn't sound right, but my client hadn't had any income and needed some income, and it was, and the way to do that, and it seemed to be accurate. I'm only guessing that. I know I made a demand for discovery, is never responded to, and as I reflect back on that, is I'm not sure if, what the attorney on that time told me that they couldn't get the records or they weren't available, but it's just in talking with maybe talking with my client and everything, it seemed to be accurate. And in moving forward, Your Honor, Justice Sundquist, you want to move forward and try and get as many issues stipulated to, a potential issue stipulated, so you don't have to address them in the future. After this stipulation for settlement was served and filed, they filed another NOID in mid-June. So there we're at, we're back at it again, and that led to some hearings. So
So, Mr. Scully, I'm sorry, did he answer your question?
He
Okay.
did. Thank you, Mr. Scully.
Was the average weekly wage material to the stipulation or to the findings in order?
no,
Okay, is
It
it
was-
material now?
it is.
Okay.
Right.
And I'll tell you what I'm struggling with. It wasn't material at the time, and I very much understand what you're saying about the urgency and wanting to move forward. And I'm also aware of what you said. When you're doing a stipulation, you try to kind of button up as many things as you can. You try to clean up as many issues as you can
Right.
so you can move forward. My concern is that if you are stipulating to things that are not material at the time, but become material later, it seems like what you're saying is, well, if it's not material at the time we stipulated to it, then we can look at it again, we can reopen it, we can litigate it in the future. Whereas like you said, the purpose of the stip is kind of to button down some things at the time. So how do you reconcile those two things?
Well, when you say material at the time, Justice Hip Carlson, it was, it appeared that the average weekly wage was correct. And that the issues at the time, and it appeared because my client was being paid at the max comp rate, that it seemed like, you know, we agreed to that. Did I ask my client about that? Did it appear to be? I can't recall. I just know that we stipulated to that with the attorney at that time when we went through the issues of resolving the pending claim.
So it seemed correct at the time, but you've since learned it was a mistake. At the end of the
Yes.
day, it's just a mistake.
Right.
Okay.
And
thank
it
you.
wasn't a mistake until, as we put on a brief, when she sought, my time is up, until she sought temporary partial disability benefits.
We're gonna let all of my colleagues ask questions beyond the 15 minutes if they choose so today on this case. So.
My question is, basically, there's other bases under the statute to vacate a petition for settlement, and you're not making any other claim or other than mutual mistake of fact.
No, Justice Christensen.
So there's no fraud allegation being made to open this petition.
You know, I will, I'm not sure, being an Irish Catholic or whatever with that guilt, but I will tell you that crossed my mind at one time, and then I bring myself down, and it was a mistake, and I think that it was just a mistake on both parties. I really believe that the mistake of fact was mutual. It's a mutual mistake of fact, and it's mutual because the employer and the insurer didn't properly calculate the average weekly wage, and in their response to discovery, they just took an annual salary and divided it by 52. And what I relied upon the first report of injury and the employer and the insurer's primary liability determination. Now, why I did that, I don't know. Was it because of the times that I'm only speculating back because of the time of COVID, and I'm reluctant why I did that. The people that taught me work comp and practice and procedures, there are 4 of them, and they all told me it was always get the wage records and determine that average weekly wage. Why that, why that happened, I don't know. And I continue to think about that and think about it and in preparing for this, and I can't come up with a, you know, a valid, I'll call it a valid reason. It'd all be speculation, Your Honor.
But the difference between what was stipulated to the $1,700
Right.
and what the records show, which is more than $2,200, is about a $500 difference.
Yes, it's about it's $2,400 and some odd dollars, a $500 difference.
And the claim being made, and which I assume is going to go forward potentially depending on what this court does, is temporary partial disability benefits. And one of the things that the Supreme Court has told us to do is to provide the employee compensation proportionate to the degree and duration of her disability in this case. And so that $500 difference makes a tremendous difference in the amount of temporary partial disability benefits that may be owed to your client. Is that
Yes.
a fair understanding on my
Yes.
part?
Right.
Thank you. That's all I have.
I have one question. Who was the original drafter of the stipulation for settlement?
It was Mr. Clefman's colleague, Beth Butler, who is currently Mr. Clefman's colleague. And subsequent to that, the attorney was Christine Cook. And then when I filed the claim for the temporary partial disability benefits, Mr. Clefman showed up on the case. So,
Thank you. Anybody else have any questions?
I'm good.
No, thank you.
Thank you.
oh, okay. Very good. Thank you.
May it please the court, my name is Brent Clefman, and I represent the Respondents Clinical Benefit Group and Berkley National Insurance Company. The relief that we're seeking today is that this court deny the employee's petition to vacate the May 2020 stipulation for settlement and award. The standard of review for these petitions is obviously well known to this court. Pursuant to 176.461, an award may, upon application of a party, be set aside only for cause. And the 4 cause requirements are obviously limited to 4 factors. I will address the cause requirement, but before we even get there, there's a more consequential legal issue to address, which is that any decision to vacate the stipulation for settlement and award from May 2020 is essentially moot because the stipulated average weekly wage is already contained in the unappealed findings from June of 2022. The employee's petition to vacate, for which we're here today, is limited solely to the May 2020 stipulation and award. Nowhere in the petition or legal briefs does the employee seek to vacate the June 2022 findings and orders. And procedure matters. Procedure limits the scope of review of this appellate court to be confined to the specific legal issues or errors being raised by the appellant. Next, there wouldn't be any legal basis to petition to vacate the findings and orders under 176.461 anyway, because and you can see from the employee's briefs in the argument is the petitioner says the average weekly wage was not properly calculated under the law. That's arguing a mistake of law, not a mistake of fact. And an error of law is not one of the 4 cause requirements that we have. And this court has already stated in the FIEC, the FIECK versus Bandrup and Associates case decided by this court in October of 2004, that the statute does not contemplate setting aside a decision and order on the basis of a mistake of law. I would also argue here today that there was no mutual mistake. The employer-insurer took the position at the very beginning of this case that the average weekly wage should be calculated based upon the annual salary divided by 52 weeks. So they were under no misapprehension as to how they were calculating it, what their position was. Again, this was a legal position that they were taking. Instead, what we have is a unilateral mistake from the employee's just failure to consider or review the wage records prior to stipulating the average weekly wage in both a stipulation for settlement and at a hearing.
I'm going to interrupt you and I'm going to turn to my colleagues and see if they have any questions.
Go ahead.
Yes, Mr. Cleffman, I think all of us have the same question. Is, it's just assuming that there was no stipulation for settlement, no agreement, was the average weekly wage correct?
So, Your Honor, I think it's important not to confuse, again, a legal argument or a legal position with a
Well,
fact.
I want to know the facts. Was the average weekly wage correct?
So possibly, again, when I was a young attorney judge, I really wanted the average weekly wage to be this precise mathematical formula that I could follow every single time. But what I've learned and that we all know is that there is no exact precise formula that we're required to follow for an average weekly wage. What we're instead required to do, as the case law says, is try to find a fair approximation of what the loss of earning capacity was for the injured worker on the date of injury. And so you can use whatever reasonable method of calculation you want to try to make that argument. And that's why in almost every case, we have these greater or lesser average weekly wages that are calculated. One's not wrong. They're just different arguments.
And I can understand, Mr. Cleffman, in cases where it's maybe $20 off, $2 off, but $500 off is the average weekly wage correct? Is it substantially correct?
So we could all sit here and roll our eyes about, okay, Mr. Cleffman, if you took this argument to a hearing, would you prevail? And the answer is probably not, but that not 100%. I mean, there is not, my client had a legal right, Your Honor, to take that legal position in this case.
How is that a legal position that they can take? I mean, tell me, what statutory authority do they have in determining that average weekly wage?
Because again, it's just about trying to arrive at a fair approximation. I mean, that's our overarching duty as lawyers, to try to make whatever arguments we can do on behalf of our client to advocate within the bounds of that. And that's why, I mean, yes, in this case, it is a big number, but it's not uncommon to have $100, $200 differences. And again, that's because in every case, I mean, I think at least for sure 90%, and I'm sure you all have similar experiences, but when I get a case and we're bringing it to a mediation or a settlement conference, or we're going to a hearing, there is a greater average weekly wage and a lesser, and it's all dependent upon what time period's being utilized by the party and what earnings they're included. And so there is great gray area for developing legal argument.
But, you know, I agree with everything you just said. I mean, and I know in my practice, I calculated average weekly wage a number of different ways. Mr. Scully conceded as much in his argument. But if we were to take all of her wages in the year prior, the 52 weeks prior, and divide it, it would be more than the $1,700 that was arrived on, because it was just her base salary that was included. So it seems like under any circumstance, it's wrong. You can't get to that number. I mean, isn't that correct?
Again, Your Honor, I can't quite go there, because as an advocate, I have to say that we can't conflate the strength or weakness of a legal argument, however weak it may be, with a mistake of fact. Again, we're talking about arguments about how something should be calculated under the law.
But I'm talking about I agree with you that there's a difference between a factual dispute and a legal dispute. But we know that there are facts out there, actual facts. What was her actual wage? Or excuse me, what was her pay? And her pay was more than just her salary. That is a fact I think we can agree to.
We can, Your Honor, but again, I think we don't want to lose sight of why we're here and the standard of review that we're looking at.
Well, it's not a standard of review, but
I-
it kind of is. I know what you mean, though.
Yeah, I'm sorry. It was
Yeah.
an inarticulate way of
that's-
saying
that's-
it.
I
But-
get what you're saying.
So think about it this way, Your Honor. So, and I'm sure that you're well aware of the Slate case, the SLAIGHT versus Exceptional Homes, decided by this case or by this court in February of 2010. And in that Slate case, it's very similar. And I apologize, it was not briefed in our brief, and that's my fault, and I take that responsibility. But it's important to talk about here since we're trying to get this right. In Slate, the employee stipulated to an average weekly wage at a hearing. 2 years later, they filed this petition to vacate because they say, well, the employee's earnings from his second job on the date of injury were not included in that average weekly wage. And so, and yet the court said, well, okay, obviously everyone was aware, like the employee was aware he had a second job. It came out in this deposition that earlier before the hearing that you stipulated to this, that he had the second job. And so the Court of Appeals here said a unilateral mistake arising out of an employee's failure to consider a second job as part of his date of injury wage does not constitute a mutual mistake of fact for purposes of a petition to vacate. And I bring that up, Your Honor, because the same kind of an analysis sort of applies here. So obviously, in Slate, you could make the same argument. Well, of course, the wage that you stipulated to wasn't right. He had the second job. He had all these additional earnings. Well, it's just the same situation.
Well,
I've got a few questions
Well,
here.
can I
wanna
follow up with that?
Sure.
So and I do understand your argument. I really do. Here we have, you know, an issue. What is the average weekly wage that really wasn't particularly material at the time because everyone agreed this woman was going to get max comp rate for temp total. You're right. She was aware of what she made. She probably had pay stubs. She did her taxes at the end of the calendar year. She probably could have done all of the math. Your client also had access to all of that. They did their mathematical calculation, however they did it on the first report and on the primary notice determination. Seems like they were wrong. Seems like Mr. Scully was wrong to rely upon you. I mean, that seems more mutual to me than the Slate case.
I understand, Your Honor, and I don't have an additional rebuttal beyond what I've already said.
Yeah.
I mean, for me, I have to keep going back to, we're still talking about, is something properly calculated under the law? So I don't have anything new to respond to
Okay.
that.
Okay, fair enough.
I do have some questions, and I can't say I agree with my colleagues on what I understand and agree with you. I'll be quite blunt. You've just told me, correct me if I'm wrong, that you have two standards of review. One for Mr. Scully's client, which is mistake of fact, but it's unilateral. And the other one is a mistake of law for your clients. Is that a distinction here that you're arguing? It's just a yes or no answer. That just comes up to me from what you just argued.
And so, yes, but I want to make sure I'm understanding something because
He's a unilateral mistake, and you have a mistake of law argument, and there is no mistake in the law.
I am making a mistake of law argument, correct?
Correct, for your clients.
For my client. I'm saying this, I'm saying if it was a mistake,
Right.
it was a mistake of law under how it's properly calculated.
Okay, and when you filed your response to the petition to vacate, you, in the factual background, said that the average weekly wage was assessed. How do you define assessed to be 1730.76? Tell me what that word means to you.
Assess means calculate.
Right, estimate, evaluate, calculate. Okay. Was the employee salaried or hourly in the pay scale?
She was set for a salary.
She was set at a salary, and if I go back to the wage records provided by your client, and I'd like to take you through that.
Sure.
Is she exempt from certain federal and state labor laws then if she's salaried? Like overtime? Because the wage rate for the 26-week period
Right?
has quite an interesting calculation analysis through the program that your clients filed. And I have to say, she's not just a W-2er.
Yeah, I mean, so the pay stubs are just straight up confusing anyway, Your Honor. I mean.
Are they?
I mean, they've got this RN 31 plus points, which is essentially the RN 31 plus points is what got her over the $90,000 salary.
So she is salary exempt?
My understanding is,
Well, if she's salary exempt, she's basically exempt from certain federal and state labor laws. So your client is either making that declaration that she's salary exempt and doesn't get overtime.
so maybe I'm not following what we're getting at, Your Honor, and I apologize
Oh,
for that.
Okay, let's go to the documents powered by Intuit Payroll.
Okay.
And I can't, I know I've got cheaters on and I can barely see them. So I have an RN 30 plus points.
Yep.
The quantity is still at 48. The rate's 43.27. That's the salary base of a 40-hour work week.
Correct. That's correct. You were right.
And then underneath that, I have an RN 31 plus points.
Yep.
That changes. And that changes. And then I have a PTO hourly, a bonus from time to time, and the bonus comes in. Are those payments paid at the date earned, or are they programmed to be paid after a certain time?
None of the answers to all those questions is not in the appellate record. It's not.
Well, it's in this record. It's
Wh-
not in the appeal. You're arguing that a first report of injury was an assessment. That's the first document of the 1703, and you base it on an hourly exempt employee, 40 hours a week.
Right.
Yet, the records you have indicate more than an hourly salary because you add then the RN 31 plus points, and those fluctuate. And
Right.
that's the overtime.
I think we need to be careful, Your Honor, because
Well,
although-
then tell me what it is. I want to be careful.
No, I 100%, and I wish we could, but you will see, and I went through the record in detail because I'm the third attorney, so I'm trying to learn everything here.
Mhm.
I did not have the benefit of doing this from the beginning. So there's nothing in the record that explains what those RN 31 plus points are. My understanding, again, I'm pulling this outside of the record, is that those RN 31 plus points that she's getting above her salary is like productivity points. It's based upon the level of services that may have been provided by this RN when she goes and does her care each week. So if the level of services is greater, like the skill set, then you can earn more productivity points, these RN 31 plus.
Telling this full court today that she is a salary-based exempt employee based on the calculations that show something different, which is the powered by Intuit payroll from your office. You're telling me she is exempt. She's not eligible for overtime pay. Salary,
I can't answer that question.
but
And,
that's
you know,
what, actually, you must answer it, and if you cannot, tell me why, because I'm asking you to tell me and show me what status this employee is in, because if she is exempt and salaried, she could be working 55 hours a week and only be paid for a salary exempt employee status. And there's certain criterias here, and I'm going through your client's payroll records. It shows something different from an exempt employee.
well, and again, so it very well may be that she was not exempt. I mean, the way that they calculate salaries, they're looked at her, so take 2,080 hours times that hourly rate, that's $90,000.
So if she was being calculated by your clients as an exempt salaried employee, when in fact she was not, That's a mistake by your clients, right?
What was,
Is it not, if it's not a mistake,
I,
then what is it?
I don't think we're talking about the same mistake as it,
Oh, I'm talking about this mistake.
I guess.
This
Your Honor-
one.
So Your Honor, does this mistake change the calculation? I mean, we're still talking about what is an argument? What is the legal?
No, you want to go back to that
Yep.
four corners of the box, and you're doing a great job trying to pivot out of it. But Mr. Cliffman, I'm asking you.
Yep.
For purposes of state and federal laws, when a person is an exempt salaried employee working more than 40 hours a week or non-exempt and working in a program of earnings per hour based on the wage records you submitted, shows that there is a payment formula outside of a 40-hour work week going on here.
I mean, that's true. That's how she was making more money above that, correct?
So when you filed the first report of injury and you, the universal you of your clients, that's an honest mistake they could make. Because if you're putting me to the four corners of the box and I look at the legislative intent of what the statute is for average weekly wage, I don't know if that's what the legislature intended, that somebody who really isn't exempt and is working a lot of overtime, wait a minute, is an exempt employee, just purely salaried.
But here's the problem. We're presuming that the extra earnings are overtime. That's not anywhere in the record. And I even went back and, I mean, again, I'm telling you things that aren't in record, but I looked at the depositions. The word overtime is never used once. Again, I don't know.
So in her pay period
Yep.
stubs, she just was getting different, the hours are different?
I mean,
And the pay differential is different? And the status is different, but that doesn't mean that it's overtime, is what you're telling me?
again, those RN 31 plus points could have been productivity pay. It could have been based upon the
For more
service
hours,
from the hours that she worked. Like,
from the hours that you work. I have one more question and then I'm going to move it down to my colleagues. You don't know what RN 31 plus points mean?
not with 100% certainty.
Okay. And do you know what RN 30 plus points means? Just the plus without the 31, the one
I
above
believe
it?
again, that just means the base salary for this RN, or the base rate.
And then a bonus also, do you know what that means? There's a bonus in here too.
Yeah, and I have no idea what that bonus is for.
Okay. That's all the questions I have.
Okay. Mr. Kleffman. Okay. My words, not yours. I understand you're saying your client, your predecessor colleague had a good faith basis to use the wage that they used. Okay. And I'm not asking you to ignore what Chief Judge Millen just asked you, but that's kind of what I heard you say before that. They had kind of a good faith reason to do that. But do you agree that the issue was not litigated? The issue of the average weekly wage was not litigated?
Yes.
And do you agree with Mr. Scully that it was not material at the time of the stip and it was not material at the time of at both hearings?
Material as in, yes, not material to the benefits being claimed at that time.
Right. It's material since she returned to work. Would you agree with that?
I would agree with that.
Okay. My question is, and I know that you didn't draft the stip, but was the average weekly wage being put into the stip then? Was that a tactical decision of your predecessor and client?
I can't answer that because I didn't draft it, but I do think it's important to consider in asking that question, the impact that this case could have on future cases if this court vacates the stipulated average weekly wage by saying it wasn't properly calculated. And here's why I think this is an important consideration. I'll give you an example that you're all familiar with. We walk into a hearing, and again, both parties have got these different divergent average weekly wage calculations. And in the 30 to 40 minutes before the hearing starts, we go on the record, the attorneys were sitting across the table, talking about evidence, talking about issues. And one of the things that inevitably comes up is, hey, average weekly wage, here's your number, here's mine. We may both have tactical reasons for why we're arguing these divergent average weekly wage. And we're like, hey, let's just meet in the middle. How about just the middle number? And yeah, sure, that sounds good. And the middle number could be $100 apart, $50 apart, $2 apart, whatever. But the bottom line is it's a middle number that has no independent factual or legal basis. I mean, there's no way you could properly calculate.
But what you're describing right now, and I think that was kind of the fact scenario of one of the cases that's been discussed, is there's actually a conversation about it and you understand where each party is coming up with their number. I have a feeling that had you or your predecessor presented your calculation to Mr. Scully saying, this is what we're using, he might have said, hang on a second, I need the records, or let's not put that in the STIP. So the scenario of a conversation is very different from what happened in your case. Do you agree with that?
I would agree with that, Your Honor. But again, then we have to be careful about the implication going forward, because none of these discussions that you're talking about where it really happening in real life, we're talking about why we're coming to this agreed number. None of that is ever going on the record. Like the judge shows up, we go on the record, the judge says, do you have any stipulations, counsel? Yes, we have a stipulation. We give them our middle number. And then later on, what happens if a party doesn't like how that stipulated middle number impacts future benefit entitlement for their client? All of a sudden, they can now petition to vacate, saying there's a mutual mistake of fact. And they come up here and they're asked the same questions. Counsel, how'd you arrive at that number? We just agreed to it. I mean, I struggle with that. I see my time is up, so unless there's more
I
questions.
just have a couple questions for you. Is this a case based upon, let me just ask this. It's the stipulated average wage is $1,700. The calculations and the documents that we have are $2,200. There's a $500 difference. And is there any, and I understand your legal arguments in opposition, but is there any factually, looking at those records, that $500 exists? Is that a fair understanding on my part?
More or less, Your Honor, yes.
And what I'm understanding your argument is that it's maybe a mutual mistake of fact or unilateral mistake of fact on the behalf of the employee and that $1,700, and on any mistake on your side would have been a mistake of law in the calculation of that number. And the case law says a mistake of law doesn't require a petition to, or is not used with, by this court or the Supreme Court to get you to a petition to vacate. Is that correct?
Yes, Your Honor.
But then we also have from the Supreme Court that says we are supposed to be fair and have compensation proportionate, and this $500 difference is a large amount of money and would potentially impact adversely the employee's claim for temporary partial disability benefits. Would you agree with that?
Yes, with my only caveat being it's a hard line to then draw. I mean, what amount is not significant? I mean, is $100 is 50? I mean, yeah, I mean, yes, 500 is a lot.
And I want to appreciate and thank you for both of you for your arguments today. But Mr. Cleffman, you're put in a difficult position today, and don't think, at least I don't appreciate that. Thank you.
Thank you.
Is anybody else?
I have some additional
Okay.
questions. I want to
Okay.
go back to your very first point
Yes.
about, hey, Scully only petitioned to vacate the step, and there have been 2 or 3 or 4 other documents signed by judges, findings and orders and so forth, where the same wage is either it's stipulated to, or it's a finding of fact that the party stipulated to it. And he didn't petition to vacate that. I agree with one of the things you said, procedure matters. We deny Mr. Scully's petition based solely on that. He files a brand new petition vacating, I want to vacate them all then. and we're all back here, should we go through that process?
Yes, I mean, yes, the short answer would be yes. I mean,
Okay.
again, procedure matters, but I do think that, I mean, and I see this happen a lot of times in Court of Appeals. You could address that argument, and you could address the mutual mistake argument as well, and still then deny
Sure.
deny the petition to vacate. But if how you lay the mutual mistake a fact, then it's what we all know what the answer is coming back. So
Right. So, but if we had just addressed it procedurally first, because that is the first step, well, Scully, you got to try again and do it all over again, then we're right back here. So is it better for us just to get to the merits and just say, if we're going to if we vacate, we're vacating all of those stipulations, regardless of which specific document it was in?
I would like to say yes, Your Honor, but the one thing that concerns me is if we're talking about vacating a stipulation that was put in the record at a hearing, I think the analysis then sort of shifts a little bit, and we need to start talking more about, well, what were the facts and considerations known more at that time? We've really focused a lot of the arguments like, well, here's what it was at the time of that stipulation for settlement.
But it doesn't, and you've talked about what is and isn't in the record, because this is a court of original jurisdiction. In my mind, it's all in the record. Mr. Scully's recollections of what was going on back then, I think, are relevant in this particular, in any kind of petition to vacate. If Ms. Butler was here, her recollections, I think, would be relevant to us. But I don't know how to quite say what I want to say here, but should we not do anything and refer it to a comp judge for fact finding on this first?
I would say no to that, Your Honor. I guess simply because nothing would change in that. I mean, my client would still take the same legal position. Mr. Scully would put in his evidence, and the judge would make a decision. And again, it's just a legal decision based upon what they think is the fairest approximation or the most reasonable calculation.
Yeah, because I mean, if we agree with Mr. Scully that it's wrong, it's simply wrong, and it is a mutual mistake of fact, I don't even think we have to get to, and here's the right number. I don't think we need to do that at all.
I
think we'd be wrong if we did that. That's what I personally think.
I would agree with you. Yep.
Okay.
Yep.
Okay.
Yep.
I have a question. What about, we have original jurisdiction, we stay our order and allow for an amendment, and thereby we approach in judicial efficiency the full gamut of the findings and orders and the original petition to vacate based on a contract that I find interesting because it was a closed period of temporary total, but the first benefit listed in the stipulation as part of this deal is a temp partial. I don't know if that's just an error or just something because the original stip didn't pay temp partial. And yet that's the first benefit you close out.
Yeah.
So staying the imposition of an order on an original jurisdiction petition and allow the parties the time period. What do you think of that?
It's a creative way to put it all together. I see some merit in that thought process, Your Honor.
Thank you. I have nothing further. You have anything further?
No, good.
Okay. Thank you.
Thank you.
The record is not closed. A decision will be issued within the statutory time frame, and if we close the record, we will send out a separate order. Thank you.
Thank you.
I'm going to ask you, since we're done with this, that we have externs, interns here. If they approach the two of you to discuss the practice of law, would both of you be available to have a brief discussion with any of them?
All those young
Thank
people
you.
in the back, with the exception of your son.
We,
Yeah, you gotta include him too, why not?
we have 3 externs with the WCCA and then 2 law clerks with the audit firm, correct?
Yes.
Okay, thank you.
Thank you
both.
all. Have a good day.